MP from Muar, Syed Saddiq, has expressed his concern that the effort to separate the powers of the Attorney General from the public prosecutor may be delayed. It may not even happen, according to him. It may be 5 years from now. Apparently, there is some pushback, there is some dispute as to how the government should carry on this promise of separating the powers of the AG and the public prosecutor. Now, I think people forget that the real problem in this country is not so much whether the AG and the public prosecutor should be different person or same person. It is the unsatisfactory conduct of the criminal prosecution in Malaysia. That is the first problem we have. Criminal prosecutions, we don't have clarity, we don't have transparent understanding of how lawyers in the AG's chambers decide who to prosecute, on what basis, what evidence do they have, what code of conduct do they have in carrying out this prosecution. They don't. It's all very opaque. So sometimes you have cases where, they prosecuted the case, and then suddenly they will withdraw the case for no reason. All because they said they have the power, the discretion to charge or not to charge. Sometimes you remember the case of Serba Dynamic, this fraud of this company on the accounts, where senior officers of the Securities Commission resigned and blocked. They're not happy with the decision not to prosecute, not to prefer charges. But we don't know why. We don't know why that was done. Why was this immunity given to this group of directors from Sarawak? All we know, this is AG's discretion. AG's discretion. Absolute discretion. Cannot be challenged. Blah, blah, blah. So this is our problem. The state of criminal prosecution in Malaysia is not transparent. It's not fair. We don't know why, for example, Ismail Sabri, who was caught with 200 million or so, with some gold bars, they were charged. Do you know why? Do you know why there were some other cases where we know there were some serious reports of corruption and all that? There was no investigation. There was no charge. It is because of this situation that the government has to address this issue first. Not so much about amending Article 145. I'll come to that later. But you have to address this prosecution, the state of criminal prosecution in Malaysia. So we have to do what England did. They have an independent Crown Prosecution Services. And that is regulated by the Criminal Prosecutions Act in 1985. That sets out the standards by which prosecution must take place. The evidential rule, the public interest rule, the code of conduct. We used to, people tell me that under our system there is an internal code, but nobody knows what those codes are. Can you imagine we have a case where one Attorney General says there, and they have 47 charges against our Deputy Prime Minister. And then you have another AG who says, no, he should be cleared of all charges, DNAA. How could such extreme position be taken based on the same evidence and facts? The public cannot accept this. That is why I said the first thing we need to do, and the first thing Ms. Azalina must do before she comes to this issue of separation of AG and public prosecutor, is to make prosecutions more accountable. Have a law, set up a law, a statute governing prosecution. how DPPs are appointed, how DPPs must act. What is it that the duties of the prosecution? What is prosecutorial misconduct, for example? What happens to that in that instance? What happens to the case? What happens when the police do not provide satisfactory evidence in a particular matter? You see, it's all very murky. It's all very unsettled. It's not clear. So, like in England, the police investigate, but the prosecution is done by the Crown Prosecution Service. They are independent. The DPPs are there to do the job. So what we need, as I said, this is the first thing we need, a law to establish how criminal prosecutions must be done in this country. That is the first thing. The second thing, of course, is that in England, the Attorney General has a oversight, what they call a superintendent role, to make sure that the Crown Prosecution Service are properly done. The action of the deputy public prosecutors are consistent with the law and with the requirements of justice. But the AG in England doesn't have an active role. He doesn't decide which case to go to be charged or not to be charged. He doesn't exercise that discretion. He has an oversight. So that is why I think here you don't need to split the role of the public prosecutor and the Attorney General. You just have to make the Attorney General more responsible and more accountable. Our Attorney General, as you know, most of them just keep quiet. They don't say anything. They don't explain. They don't justify, because they have this thing called discretion, absolute discretion. Now, we should be clear. There's no such thing now in this day and age. Nobody has absolute discretion. Everyone has to justify, has to earn their keep. The Attorney General must explain the decisions made by the prosecution, whichever way it goes, where it involves public interest, where it is controversial. So that is why I keep saying the Attorney General has to be a member of the Cabinet. And through that, he has to answer to the public if there are any shortcomings of the prosecution's office. We have to make him, the Attorney General, a member of the Cabinet, so that he can answer to Parliament, he can answer to the press, he can explain certain things. But he doesn't have a full-time job in the Crown Prosecution Service, in the prosecution's office. That is done by the DPPs, by the director of the office or whatever. So we split the functions. That's what we have to do. So I hope we can, in this parliamentary session, still proceed with this effort to prevent the Attorney General from having absolute power, to prevent the prosecution from having absolute power, can do whatever they want. But everything they do must be in accordance with the law, with the statute governing prosecution, and in accordance with the principle that no one is above the law. And that is important. Of course, people say at the end of it all, whichever structure we put in place, you still need to find the right person. But I think it is true, and it's not easy, but the right person the chances of getting the right person is higher if that person knows he's being watched, that his powers are limited by the Act, limited by the law, limited by the fact that we no longer accept absolute discretion. We take that out. There should be some discretion, but it must be something they can defend, they can justify. So that is what I think we should do. Don't rush into splitting the 145 and then as if by doing that everything is hunky-dory. It's not going to do that, So I hope members of Parliament will take note of this. Thank you.